Good afternoon.
Afternoon, your
Any state lawyer
Afternoon, my lord.
present? GP
My lord,
or
one bail
yes, Mr. Prasad.
my lord, I want may I mention one bail application 902 of 2022. This was listed last week, and what direction was given to remove the defect. All the defect have been removed.
Oh,
Who accused has been
this is not the mentioning bench of bail. You go through the list. Mentioning bench is before the. This is a stopgap arrangement.
Lord.
Any state council present in the GA, GAGP? Anyone? Where is Mr. Ashutosh Anand? Connect him. Mr. Ashutosh Anand. GP, GA, Senior Standing Council. Anyone is there?
My lord, I'm AC2, SC1, my lord.
Tell Ashutosh Anand to join. AG. Yes, Mr. Ashutosh Anand.
Yes, my lord.
I have received a letter from District Bar Association Kodarma. They have showed their helplessness and the desperation. The situation is so grave. There are 4 courts of DJ and including the district judge. There are 3 other district judges and PDJ 1 PDJ and 3 district judge. And there are 9 magistrate courts.
My lords.
There is no public prosecutor and there is 1 assistant prosecutor, public prosecutor.
My lord,
This scenario is everywhere. You just I'm keeping to because the order which I am passing, I'll pass in your presence. Your name will be noted. This I am taking it as a PIL and I am referring to the division bench. Take down. A letter has been received by me from the District Bar Association Kodarma, jointly signed by the President and the General Secretary of the District Bar Association. Letter dated 22/2/2022. Next paragraph. The letter projects the desperate situation which is prevailing in the court. Full stop.
My lord, may I indicate, my lords,
which
subject lordship and position.
Which they are facing. Just listen.
My lords,
yes.
My lords, though I'm not sure, my lord, but perhaps the appointment process was on. If my lord may kindly give me a time of 5 minutes, my lord, I'll be back within 5 minutes.
I don't know. Listen. Tell me. In delivering justice to the litigants. First stop. Next paragraph. In the letter, they have brought to my notice that there was only 1 public prosecutor who was catering to the principal district judge and to the 4 sessions court, catering to the 4 session courts. Full stop. The state public prosecutor superannuated on 31st December 2021, and hence there is no public prosecutor to cater to the sessions court in Kodarma. From then there is no full stop. Further, it has been mentioned that there is Court of Chief Judicial Magistrate, Additional Chief Judicial Magistrate, Subdivisional Judicial Magistrate, and 7 other magistrates. Full stop. In these magistrate courts, there is only one assistant public prosecutor. There is only one assistant public prosecutor who is catering all these magistrate courts. Magistrate courts, including the courts of SD, CGM, SDGM, and additional CGM. Full stop. Next para. This is really a sorry state of affair. Non-availability of the public prosecutors or shortage of public prosecutors is definitely a big block in justice delivery system. And this cannot be tolerated. Full stop. Next one. Oh, in the same line. This is not only the case in the district of Kodarma, but throughout the state of Jharkhand. Full stop. In many district courts, civil courts of the state, in this state, there is acute shortage of public prosecutors. Full stop. The direct effect of shortage of public prosecutor is that the witnesses cannot be examined when they appear to depose before the court. They are forced to return and to come again. Full stop. Considering the serious issue, the letter is treated to be a public interest litigation, and interest litigation, full stop. Let this letter form a part of this record. Full stop. The letter be instituted as a public interest. I direct the registry to institute this letter as a public interest litigation and forward the same along with a copy of this order. Forward this public interest litigation and direct the registry to list this public after registering this public interest litigation, list it before an appropriate bench immediately with the approval of honorable with the approval and permission of Honorable the Chief Justice. Good stuff.
My lord, a copy of the order along with the letter.
Copy of order and a copy of this letter be handed over to Additional Advocate General Sri Ashutosh Anand, who is present in this proceeding.
Obliged, my lord. I'll just get the facts also, my lord, of this matter.
Yes, immediately. Okay. Yes, next. Call the cases.
From daily causes under the heading orders with defect, serial number 1, BA number 12586 of 21, Mr. Virat Kumar, Mr. Gautam Kumar for the petitioner.
Sir, I want to withdraw this application. Petition has already been acquitted.
Withdraw. Dismissed as withdrawn.
I attend state for state Kumari Rashmi.
Yes, give it a slip.
Serial number 2, BA number 14427 of 21, Mr. Indu Shekhar Gupta.
Yes, Mr. Gupta.
यस लॉर्डशिप इस पे है जो कस्टडी काफ़ी दिन हो गया है 7/1/2017 से हैं और 9 विटनेस हैव बीन एग्जामिन माय लॉर्ड आउट ऑफ 12 चार्जशीट विटनेसेस 12 में से 9 हाँ 9 विटनेसेस यही मेरा
Earlier rejected.
यस माय लॉर्ड अर्लियर रिजेक्टेड
Case under section 302.
302 है जो 307 का है 147 148
There is direct allegation against you, most probably.
लॉर्डशिप
Let the trial conclude. Yes. Which place, Dumka? Only 3 witnesses remaining.
हाँ 3 विटनेसेस बाकी है
Together from the interview order, I find that only 3 witnesses remains to be examined in this case. As there are, as 9 out of the 12 charge sheet witnesses have already been examined. The prayer of the petitioner was earlier rejected since there is a direct allegation against the petitioner of commission of murder. I am not inclined to release the petitioner on bail, dismissed. However, next para, the trial court is directed to take up this trial and record the evidence of the remaining 3 witnesses on a day-to-day basis within 2 months after intimating the prosecution about the dates and the schedule so fixed. Thereafter, the trial court will try to dispose of the case as early as possible, dispose of the trial as early as possible. It is made clear that the state will produce the witness immediately on the date. Will produce the witness on the date the court so fixes, the trial court so fixes. Yes, next.
PL number 3, PL number 1311 of 22, Mr. Rajesh Kumar.
But the defect may be ignored, Lordship. So only type copy is required to be filed.
This
and
is a
handwritten.
earlier rejected matter.
No, Lordship, sir, 200 kg ganja has been recovered from the vehicle of the petitioner.
Very good.
And petitioner, the driver, it has been stated that one Sonu Kumar has been loaded the same in the aforesaid truck.
Petitioner, counsel for the defects ignored. Counsel for the petitioner submits that the petitioner is merely a driver of the vehicle who was transporting, which was being used in transporting the contraband material. He submits that being a driver, he has to act as per the direction of his employer, and he has he doesn't have any independent choice. Full stop. He further submits that it is Sonu Kumar who was transporting the material and not this petitioner. Oh, and the petitioner has got no role in the entire occurrence. What's the next para? A truck bearing registration number BR01GG 1483 was intercepted, from which 200 kg of ganja was recovered. This petitioner was the driver of the truck and was transporting the same. Full stop. Considering the nature of allegation and the quantity of the contraband material, I am not inclined to release the petitioner. Dismissed.
Serial number 4, PL number 1335 of 22, Mr. Deepak Kumar Sinha.
I am appearing on behalf of the petitioner.
Yes.
Lordship, the offence is under section 363, 366A, 376 of
Yes.
IPC and 4 and section 8 of POXO Act.
Yes.
The allegation is that I took away the victim and I kept her in Ramgarh for 2 days and 5 days in Ranchi, and thereafter I forcefully committed established physical relation upon the victim.
Yes.
Millards, my submission is, Millards, while she was traveling with me as a list to Ramgarh and Ranchi, she did
She has
not.
it's absolutely condoned. She has not made any hue and I am with you. I am with you. So for about sexual assault, for forcible sexual assault, which she says.
Millards, what I am submitting is, Millards, the entire story is false. It is with ulterior motive. The entire FIR has been lodged. And
Renew your prayer after the girl is examined. Heard the counsel for the petitioner, heard the counsel for the state. Counsel for the petitioner submits that the entire prosecution case is absolutely false. He submits that the petitioner has been falsely implicated with ulterior motive. Submits.
Hello, the petitioner is a minor, my lord.
Admittedly,
A victim is minor, sorry. Victim is minor, my lord. The age about is
the entire brief. Mr. Counsel, what do you think? Only to say that you have interrupted. I have gone through the entire file and you see, you are assuming that the victim is a minor. I have not gone through it. Admittedly, he submits that admittedly the girl accompanied this petitioner from Ranchi to Ramgarh and to
from Bokaro to Ramgarh and thereafter to Ranchi.
From Bokaro to Ramgarh and then to Ranchi. But while traveling for this period, she has not made any hue and cry. This clearly suggests that the girl on her own will has accompanied this petitioner, and the petitioner has not kidnapped the girl. First up. Next para. Even if the aforesaid argument of the petitioner is accepted, but then also a fact remains that she has alleged that the petitioner has forcibly established physical relationship with her. Full stop. This, the girl is a minor. Full stop. This, considering the fact that there was forcible physical relationship which was established by this petitioner, I am not inclined to petitioner upon the minor girl. I am not inclined to release the petitioner at this stage. Rejected. The petitioner will be at liberty to renew his prayer after examination of the victim during trial.
Serial number 5, DA number 1513 of 22, Mr. Vikas Kumar.
Lordship, in this case, my parent lordship. Case is under section 17, 21B and 27, 29 of the NDPS Act lordship. 1.4 grams of brown sugar, it is alleged that has been seized from the petitioner lordship. Although the recovery is less than a smaller quantity lordship.
Maybe. You remain not at this stage. It is alleged that 1.400 gram of brown sugar in 9 sachets was in 9 sachets. No? Yes?
Yes, 9
What?
sachets.
Akhtar.
I am MD Akhtar.
Of brown sugar was recovered from the possession of this petitioner. Considering the material which is brown sugar recovered from the possession of this petitioner, that will 9 sachets. In 9 sachets, I am not inclined to release the petitioner on bail at this stage. Rejected.
Obliged.
DA number 1554 of 2022, Mr. Salesh Kumar Pandey for the petitioner.
Yes, Your Lordship.
Yes.
Yes, Lordship. In this case, Your Lordship, similar case में दो case file हो गया, Lordship. One case of the BA number 1554 and another case was 1862, Your Lordship. Of 2022, Lordship. Similar putting है, same PS case number, same ये है.
Same accused.
Same accused, Your Lordship. How, as per the instruction of my clerk, Your Lordship, stated that कि हम online और hard copy हो गया, there is that some mistake of this office. Your
No,
Lordship.
online has been registered as a particular case and the hard copy has been registered as another case.
Another case, Your Lordship. One BA number, Lordship, today has been listed BA number 1554 of 2022, and another case is 1862 of 2022, Your Lordship.
Let's discuss on Monday before this court along with BA number
1862 of 2022, Your Lordship.
of 2022. Monday को देखते हैं.
Lordship.
Under the heading fresh filing, serial number 7, DA number 16171 of 21, Mr. Niranjan Kumar.
Yes, my lord, earlier rejected, my lord. Kindly see the last order, Lordship.
Last
Which
order.
is the last order 28/7/2021.
Have you
The
annexed?
Lordship. No, I have not annexed, Lordship.
How many times rejected?
I think Lordship 4-5 times, Lordship. 4 times, I think.
4 times.
Lordship, annexure 4, my lord. First of all, kindly see the annexure 4. I have annexed the Lordship.
So with the 3 more charge sheet. How many witnesses examined?
My lord, entire witness have examined. Only one witness has been left. Only the IO, Lordship. The Lordship has directed to rejected the bail petition to 28/7/2021 for examination of the IO immediately. My lord, after rejecting the bail petition, Lordship, 13/8/2021, page 69, Lordship. The entire order sheet I have annexed, Lordship.
Yes.
69 page, Lordship.
Yes.
13/8/2021, IO present but is not feeling well, suffering from the acute neck pain. He has been discharged. Thereafter, till today, my lord, they have he has not appeared and he has not been examined. Also.
Where is Ayub?
First, I am appearing for the informant. If your lordship may permit me to make some submission, my lordship.
Where is Ayub? Yes.
First, since sir, I am appearing for the informant, my lord. My lord, in this case, but some facts are there.
I'm not on the facts. Where is the Ayub? Yes, with the state.
Yes, Lordship, I am appearing, Lordship.
When will the Ayub appear?
Lord, I'll take instructions, Lordship, or as Lordship may direct.
Tuesday, second half.
Lordship?
There is this case on Tuesday at 2:15 when the APP will inform this court as to when. Oh, Tuesday holiday hai. Monday at 2:15 when the APP will inform this court the date when the IO will be produced for recording the evidence. Yes, what do you have to say, Lalit Yadav now?
My lord, since so far the case, my lord, it was the allegation.
Who is hearing the merits of the case?
No, my lord, but just I am for a moment, my lord. My lord, so far on the application, my lord, an application on the section 311 was filed, my lord, for examining the victim, my lord. That order was challenged before this honorable court, and wide your lordship's effort, all the witnesses were examined, and subsequently, my lord, that order has been set aside by this honorable court, my lord, on the moment when all the witnesses were examined, my lord. Similarly, bail applications were heard by your lordship and CRMP was filed, my lord. And the day when the CRMP was allowed by this honorable court, all the witnesses under 311 were, my lords, they have been examined, but that was not brought and it was set aside by this honorable court, your lordship.
Nothing to do. Let the trial conclude. I am only interested for conclusion of the trial. How many?
By your lordship efforts, my lord, since the application under 311 was allowed, there was 10 witnesses, my lord. Even the doctor was not made a charge sheet witness. That is why 311 was filed, my lord. 311 was allowed, my lords, and the 311 order was challenged before this honorable court. And bail application were filed, my lords. On the intervention of your lordship, all the witnesses were examined, and that CRMP was, my lords, allowed, my lords.
Allowed, so the court will decide what to do. Yes, let the IUP examine. Yes, next. Yes, 215.
Area number 1193 of 22, Mr. Arun Kumar for the petitioner.
This anticipatory bail application earlier rejected by your lordship. This is the case by the offence under section 414 and 34 of the IPC and section 33.
Not maintainable.
My lord, after rejection, my lord, was the two more persons, my lord, was the driver, owner of the vehicles have been granted bail.
Yeah, you see the order of the judgment of the Honorable Supreme Court, which was a month or 2 months back. That once an anticipatory bail is rejected, you have to surrender. A second anticipatory bail has been filed even after rejection of the earlier one by the petitioner. Only on the ground that two other accused has been granted the benefit of anticipatory bail. Full stop. This cannot be a ground. Yes, one or two.
Owner of the vehicle, my lord.
Owner of the vehicle has been granted anticipatory bail. Full stop. This cannot be a ground to reconsider the anticipatory bail, which was already rejected on
24 October 2018.
24th October 2018. It is surprising. The petitioner did not choose to surrender after rejection of his anticipatory bail in the year 2018. Rather, in 2022, has moved this court again seeking for anticipatory bail. Full stop. This anticipatory bail is thus rejected.
Area number 9, DA number 1662 of 22, Mr. Raja Ravi Shekhar Singh.
That's tied up matter. One witness is left due to non-availability of the court since 8 months.
Which court? Non-availability.
Trial court. Which appears from the page 17, Lord.
Yes, let's see.
Page
No,
17.
It is before which court?
Pending before the principal session Judge Simdega.
So you mean to say there is no principal session Judge Simdega?
It is come in the impugn order, my lord.
Well, read that.
From the bottom third line, my lord.
Yes.
Principal district and session Judge Simdega was vacant from the last 6 months.
Was vacant. Now he has already joined. He is not an in-charge court. He's a
No, my
permanent
lord.
court.
According to my instruction, he has not joined, my lord. Since 8 months, 6 महीना उधर इधर 2 महीना से अभी तक ज्वाइन नहीं किए हैं.
What submission you are making, Mr. Counsel?
Yes, my lord. I specifically I have taken instruction and from the court.
What sort of submissions? This order is 7/12/2021, passed by the session Judge Simdega.
Yes, my lord. 2 months before.
Yes. The case was pending before which court?
The principal session Judge Simdega. And it was dismissed by session Judge Simdega, which appears from page 18. It is pending before the principal session judge and dismissed by the session judge. Page 18, will not kindly have a look. And custody since more than 4 years.
No.
Office of Learned Raji is informed, he is joining.
Let me seek.
Any
on the
condition for because a free person can be prove himself innocent and all हुजूर एक फ्री आदमी है अपने आप में जेल में रहेगा हम हमें कैसे प्रूफ करेंगे हुजूर इतना दिन से हम कस्टडी में है कम से कुछ दिन की
Go and move an application for to change the entire CRPC.
There's a consideration of
And remove the provisions for taking a person in custody and arrest. What sort of submission you are making? There's only one witness left. At best, the trial can be concluded.
Yes, one witness is left since Lord earlier this matter was rejected last year in the month of February. 5/2/2002 in BA number 6550 of 2020. That time 2 witnesses were left. Subsequently, doctor has been examined and due to non-availability of the learned trial court, the case is pending.
Yes, where is the Registrar General? Seek instruction whether there is a permanent principal district judge. Simdega is there or not, or the post is still vacant, the court is still vacant. Seek instruction. Simdega.
Please join us. Ahmed has joined. He's just joining now.
By the counsel for the petitioner, he renews the prayer for bail of the petitioner which was earlier rejected. First up, counsel for the petitioner submits that the petitioner is in custody since 25/2/2018 and only one witness remains to be examined in this case, who is not being examined as the court of principal district and session judge Simdega was vacant since last 6 months. 8 months, first up. He submits that the sessions trial 137 of 2018 is pending before the principal district and session judge Simdega, and the bail application, which was registered as criminal pending bail application, which was registered as criminal misapplication number 322 of 2021, was heard and disposed of by Session Judge Simdega and not the principal session district and session judge. He submits that this dismissal order is dated 7/12/2021, which would suggest that the court of principal district and session judge Simdega is vacant. Full stop. Next para. On his submission, this court requested the Registrar General of the High Court of Jharkhand. The court of principal district session judge Simdega is vacant.
No, Lordship. It is not vacant, Lordship. Mr. Rizwan Ahmad is the principal district judge at Simdega.
When did he join?
Lordship, probably in November, Lordship.
No. It is dismissed on December, Milon.
December?
By the session judge, Milon.
Okay. I requested the learned Registrar General to inform this court about the status of the office of the principal district judge Simdega. Full stop. The learned Registrar General informed that Mr. Rizwan Ahmed has informed that the principal district and session judge of Simdega has already joined. An officer has already joined as the principal and district judge Simdega. Full stop. Next para. Okay, thank you, Registrar General. Mr. Registrar General, I have instituted a PIL on a letter. The order sheet will reach you. Ensure compliance of that immediately to list before an appropriate bench.
Lordship, my lord.
Yes. Okay. Full stop. Next para. Considering the fact that an judicial officer has joined the post of principal district and session judge Simdega, and only one witness remains to be examined in this case, I am not inclined to grant bail to the petitioner. The principal district and session judge Simdega is directed to record the evidence of the remaining witness and immediately and conclude the trial on a day-to-day basis. This case is dismissed. Application is dismissed. Let this order be communicated.
Rizwan Ahmad is district judge, session judge.
Yes, next.
Under the heading for admission, serial number 10 with serial number 11, criminal division 684 of 18, criminal division 708 of 18, Mr. Samit Saurabh for the petition in first case, Mr. Hemant Kumar Shikarwar for the petition in second case.
Yes.
My lord. Lord, this application has been against the order of discharge, Lord. This revision application has been filed.
Yes.
My lord. On the last occasion, my lord, have directed the CBI to show the records by which conspiracy can be proved by any document that there was a meeting of mind, but not in the council of the CBI has.
Yes.
My lord, a week's time, my lord, because the order I could not find on my record, my lord. I just am there with the file, but record I have to call for, my lord, and to highlight that aspect of the matter, my lord. So a week's time may be given, my lord. For that, because I will go through the last order, my lord. My learned friend has submitted that probably there was some specific query that had come from my lord's side. What is the material to establish conspiracy?
That is not in the order. That during course of argument I directed.
So by that, then I have to, because I was not aware of this part.
The ASG, Mr. Prashant Pallav, prays for some time to address this court as to what are the materials in the case diary to suggest the angle of conspiracy which has been alleged against this Komadeko, which has been alleged against the petitioner. 2 weeks?
2 weeks, my lord. Good enough.
This case is after 2 weeks.
But next Friday, this may be listed, Lordship.
2 weeks.
My lord, one small request submission was there, my lord. In item number 3, my lord, I just could not log in. There was some network issue. So it was taken from last Tuesday to Friday. It was that NCB matter, my lord.
It's dismissed.
My appearance could be taken.
Give yourself, your appearance will be noted. Yes, next.
Read for me.
Division 11 of 19, Mr. Rahul Sabu, Mr. Goram Vidyadia, Mr. Amit Kumar Gyase, Mr. Jagdish for the petitioner.
May it please your lordships.
Yes.
My lords, the petitioner has challenged the order whereby his discharge application has been rejected by the learned court below, my lords. Now, page 70 is the impugn order.
Read this.
My lords. My lords, I am coming to relevant portions, my lords. If your lordship so permit me, I will come to directly to the finding of the court. It is a case.
Let us read what is the case background. I will get it.
Petition for discharge dated 6/10/18.
71.
Page
From page
71.
Yes.
My lords. Learned counsel for the petitioner submits that as per allegation made in FIR, White Building Plan number 892/2004, dated so and Building Plan number 1214/2007, 2 map for building construction was sanctioned for construction of same building, Block A and Block B, Kumud Complex, Pisca Mode, Ranchi, as because the petitioner is admittedly a builder. Block A was for B plus G plus 4. G plus 1 plus 2 floors were sanctioned for commercial area, and 3rd and 4th floor were sanctioned for residential purpose. One Vijay Kumar Chaudhary and Rajesh Kumar Chaudhary have purchased B plus G plus 1st floor and 2nd floor, along with parking area of Block A, and accordingly a revised building plan for 3rd and 4th floor has been sanctioned as commercial area, and same is converted into hotel without parking area. It is further alleged that Block B has been sanctioned as G plus 7 storied building, but the construction has been made G plus 8 storied, but there is no sufficient parking space in Block B, and some parking place meant for Block A has been shown to be setback area as required for sanction for the same building. It is further submitted that as per allegation on the date when the plan was sanctioned, UC case number 41/2008 was pending, and therefore the sanction of such plan was against the law. In collusion with Sri Gopal Das, Vice Chairman of RRDA Ranchi, this petitioner has got the said plan sanctioned on the strength of gratification, and also in collusion of other officials of RRDA Ranchi. Learned counsel for the petitioner further submits that whole case is bad in law, and admittedly the petitioner is not a public servant. There is no allegation of using any forged document as genuine, nor there is any case of cheating and forgery. Cognizance has been taken under section 420, 406, 408, 409, 120B of the Indian Penal Code, and section 12 and 13 subclause 2 read with section 13(1)(d) of Prevention of Corruption Act 1988 against this petitioner and others. But on consideration of the allegation as made in FIR as well as in the police diary, no charges as stated above can be framed against him. There is no allegation of abatement of giving bribery and also of cheating or forgery against this petitioner. It is further submitted that for the alleged deviation, addition and or defects in the said building plan, Section 35 and 36 of Jharkhand Regional Development Authority Act 2001 is in force, for which a penal provision is provided under Section 52 of the said Act, in which there is provision of levy of fine along with imprisonment. It is not the matter of trial in this court, but of RRDA Ranchi. It is further argued that against the said deviation, RRDA sent a notice of demand to deposit additional fee of rupees 1,37,785, which has already been deposited by the petitioner, and further a demand was made for rupees 2,55,816, to which also the petitioner has already deposited as final fee, and by virtue of acceptance of said fee, the effect of Section 32 and 35 of the RRDA Act has come to an end, and now no criminal prosecution is required against him. Therefore, there is no ground to frame charge against the petitioner, and thus he may be discharged.
Who is appealing for the
Learned
vigilance?
special.
Who is appealing for the vigilance?
Yes, Your Lordship, I am for the vigilance, Your Lordship. Your Lordship, after the preliminary inquiry, the FIR has been filed, Your Lordship, and as per the FIR, there is allegation of misrepresentation, cheating and perjury in the document, and also taking into connivance the officers of RRDA Ranchi, including Vice Chairman, got the map of this.
Madam, don't say forgery, because cognizance has not been taken under Section 471, 468. Don't say forgery.
420 minutes only.
Yes,
420.
420 and 109 of.
What is 12 of the PC Act?
Yes, Your Lordship. 12 PC Act, Your Lordship.
Listen to the other question. The question number 2. Admittedly, there is a deviation in the building plan.
Yes, Your Lordship.
The building was constructed with the deviations.
Yes, Your Lordship.
Now, whether those deviations was condonable or not condonable.
Your Lordship,
You have to get some fees.
yes.
What does it mean?
RRDA demanded the deviation charge.
Some deviations can be condoned after taking necessary fees.
Yes, Your Lordship.
And some deviations, even after payment of fees, cannot be condoned. That means though that portion has to be demolished.
Yes, Your Lordship.
What is this deviation?
Your Lordship, there is allegation that there is no parking area and no sufficient.
You understand the question which I am putting to you and try to answer that. Don't try to deviate here. Over here, deviation will not be condoned by me.
No, Your Lordship. That is there, Your Lordship.
In a building, there is a building plan.
Yes, Your Lordship.
A building has to be constructed as per a building plan.
Yes, Your Lordship.
Now, while constructing, there is a deviation. Now, deviations broadly, as far as we understand, it's 2 types. One which can be condoned by paying a fee, penalty, XYZ by revising the plan. The plan is revised. Second, which cannot be condoned.
Yes,
in that case, if there's a deviation is beyond condonation, it's not condonable, that structure has to be brought down.
Yes, Your Lordship.
Now, this deviation is coming within the purview of condonable deviation, or it is not condonable? Tell me.
Your Lordship, then I will take instruction, Your Lordship, because regarding this, I have no any instruction. And in this case, Your Lordship, charge has already been framed, Your Lordship.
If order goes, the charge will go, everything will go, he'll be discharged.
Yes.
But point number 2, what is the evidence to attract Section 12 of the PC Act in this case? Just because a wrong order, a plan has been sanctioned. A plan has been sanctioned?
Yes, Your Lordship. With the connivance of the officers.
If I may be permitted to intervene, my lords.
Tomorrow, just a minute. Tomorrow, if I pass a wrong order, you will say the client has connived with the judge, and so case under Section 12 or 13 of the PC Act. Show me what is the material. The evidence would be strict enough. Show me from the entire case diary. What is the material to attract connivance? Section 12, what does Section 12 says?
Yes, the section 12 says, Your Lordship, punishment for abatement of offences, Your Lordship.
Yes. Offence of which offence?
Whoever
Section
abates
7 and 11.
7?
7 and 11.
So 7 and 11?
Yes, Your
So
Lordship.
first of all, there should be an offence under section 7 and 11. So where is that offence under section 7 and 11? No, 12 is punishment.
Yes, Your Lordship.
Whoever
12 is
abets
punishment.
is punishable under this act. So this is a penal section under this act. Whether or not that offence is committed in consequence of the abatement shall be punished for 3 years. What is the offence which has been abated? Tell me.
Your Lordship, the building plan, which is not as per the law of RRDA, passed by the officer of the RRDA with the connivance of this petitioner, Your Lordship. So there is section 7 is applicable, Your Lordship.
So what is the material? Wrongly a building plan has been passed. So in every wrong order will attract section 11, you mean to say? Your argument, if I accept your argument, that means every wrong order, every order which doesn't confirm some of the provision of the law will attract section 11.
No, Your Lordship, that is not there, Your Lordship.
Then tell me what is the material?
Para 5 of the FIR is, Your Lordship, regarding this petitioner.
I am setting aside this order, remanding the matter to the court to pass a fresh order. Absolutely
Yes,
non-speaking order.
Yes, Your Lordship, that is it.
Together, heard the counsel for the petitioner, heard the counsel for the state. The petitioner has challenged, in this case, the petitioner has challenged the order dated 10/12/2000.
On the factual aspect, my lords, I may point out, initially the sanction plan was passed in the year 2004. We have made an application for revising that sanction plan. That was revised, requisite fee was asked, we have deposited the requisite fee. Now what the prosecution says that this revised sanction plan has been sanctioned after giving some illegal gratification without having any evidence, my lords. It is not the case that we have deviated from the plan.
The petitioner has challenged the order dated 10/12/2018 passed in criminal application number 1041 of 2018 arising out of vigilance case number 25 of 2009 within bracket vigilance PS case number 20 of 2009, whereby a discharge application filed by the petitioner under section 239 of the CRPC was dismissed, and the trial court has held that there are materials to proceed against the petitioner under section 420/109 of the Indian Penal Code and section 12 of the Prevention of Corruption Act. Full stop. I've heard the counsel for the petitioner and I've heard the counsel for the state. Full stop. The allegation, the petitioner, who happens to be the builder, is alleged to have constructed a building in deviation of the mandates of the building plan. Full stop. It has been alleged that initially a building plan was submitted, but thereafter, by paying necessary fees, the building plan was sought to be revised, which was revised. It is alleged that said revision was obtained after illegally, and thereafter the construction was also made in violation of the provision of the building bylaws and the plan. It is alleged that this was done in connivance with the government officials by bribing them. Full stop. The counsel for the petitioner argues the case on merit, but this court is refraining from giving any observation on merits, as it may not prejudice the trial court. Full stop. This court intends to set aside the impugned order only on the ground that the same is non-speaking, And though, non-speaking, full stop, though the court has held that there are materials to attract offense under section 420/109 of the IPC and section 12 of the Prevention of Corruption Act, but I find from the impugned order that the factual foundation to attract the aforesaid two sections have not been dealt with by the court below. Section 12 of the Prevention of Corruption Act provides for punishment of abatement of offences. First up, the provision, the act, the section provides that whoever abates any offence punishable under the act shall be punished with imprisonment. Full stop. This clearly means that an offence under the provision of the act, that is either under section 7 or 11.
My lord, 7 and 11.
11 must have been committed by some person. Full stop. In this case, there is nothing, in the impugned order, there is nothing to suggest that what is the factual background to attract any offense punishable under the Prevention of Corruption Act. Full stop. Next paragraph. Further, section 420 is the punishment for cheating. Full stop. Section 415 defines cheating, which is punishable under section 420, which is quoted below. Full stop. There is nothing in the impugned order which, from where this court can gather that section 415, that offense under section 415 is made out. Full stop. Next paragraph. To frame a charge under a particular section, there has to be a factual background which attracts the penal provision of this penal provision. Full stop. Further, when a discharge application is filed, it is incumbent upon the court, to at least refer as to what are the facts which attracts the penal provisions and whether the ingredients of those sections are fulfilled or not. Full stop. It is true that the defense version will not be accepted at this stage, but at least the prosecution version should be clear enough to attract a particular offense, and the ingredients of those offense should be made out from the prosecution version. And this, full stop, this has to be reflected in a discharge, in an order which is passed by the court while dealing with a discharge application. Full stop. All these ingredients I find missing in the impugned order. So thus, the impugned order is set aside. The trial court is directed, impugned order is so and so is set aside and quashed. The trial court is directed to set aside. The trial court is directed to rehear the petitioner and this state and pass a fresh appropriate order considering the factual foundation vis-a-vis the penal sections. If any attracted. Penal sections, if any attracted.
Obliged.
This application stands allowed with the aforesaid direction.
Serial number 13, DA number 10528 of 20, Mr. Indu Shekhar Gupta for the petitioner.
इसे लास्ट ओकेजन में मैंने करंट स्टेटस रिपोर्ट मांगा गया था, ऑफेंस अंडर सेक्शन 302/34 ऑफ द आईपीसी है। इसमें 4 विटनेसेस एग्जामिन हुआ है, Informant is not eyewitnesses and 3 witnesses are hostile.
What is the earlier rejected?
Earlier rejected, my lord.
Is the order? Mr. Gupta, you have annexed the earlier order.
Lordship, ये रिजेक्टेड वाला तो नहीं है एनेक्स किए जो, लेकिन बेल पिटिशन में आया हुआ है, बेल ऑर्डर में आया हुआ है.
Okay. The prayer for bail of this petitioner was earlier rejected on 7/12/2018. Full stop. The petitioner renews his prayer on the ground that only 4 witnesses have been examined out of 12. Full stop. He also submits that there are no admittedly there are no eyewitness to the said occurrence. Next paragraph. I have perused the impugned order and the order by which the prayer for bail of the petitioner was earlier rejected. First of all, this clearly suggests that there is no eyewitness to the occurrence. The only material against the petitioner is that the weapon supposed to be the murder weapon was recovered on the confession of this petitioner. First of all, a report was called for from the trial court. Next paragraph, from where it is clear that it is at least it will take 1 year for the trial to conclude. Considering the fact that it is not possible to conclude the trial at the earliest, and the petitioner is in custody for more than
1/3/2018 से है जो more than 3 years above.
Nearly 4 years.
Nearly
4 years, and there is no eyewitness to the said occurrence. 10,002 sureties with a condition: he will appear before the trial court at least once a month.
Lordship oblige.
DA number 14, DA number 12815 of 21, Mr. Jain Upadhyay for the petitioner.
Yes, Lord, APP साहब से ट्रायल कितना दिन में खत्म करने का डायरेक्ट?
Yes. Who is the PP?
हुजूर चार्ज फ्रेम के लिए मंगवाए थे पिछला डेट में शायद.
चार्ज फ्रेम हुआ कि नहीं?
वही रिपोर्ट मांगे थे हुजूर, कोर्ट से ही मांगे थे.
How many witnesses are left?
एक भी नहीं हुआ.
There are 6 witnesses, my lord. There are 6 witnesses.
2 witnesses have been examined in your case.
Yes. Now 4 is left, my lord. Okay, altogether 6 witnesses are there.
The case is under section so and so, so and so. The report suggests that 2 witnesses have already been examined in this case, comma, the last witness examined is on 16/2/2022. First up. Considering that the trial of the petitioner is under progress and as per the APP, 4 more witnesses needs to be examined.
There are total 6 witnesses, my lord.
4 more witnesses needs to be examined. As there are total 6 witnesses, I direct the trial court to record the statement of the witnesses on day-to-day basis and conclude the trial. Dismissed.
DA number 15, DA number 16334 of 21, Ms. Jasminda Majumdar for the petitioner.
Your Lordship, in this case, yesterday only I filed the supplementary affidavit regarding the antecedents of the petitioner, Your Lordship. And he has been, in how many cases he has been acquitted and how many cases the trial is there. So last night I sent through mail also, Your Lordship. I sent through mail, Your Lordship.
How many witnesses left?
Your Lordship, 9 witness हुए हैं. Last witness examined हुआ 26 November 2020. 26 November 2021 के बाद एक भी witness नहीं हुआ, Your Lordship. And charge framed हुआ था 22nd July 2016.
How many left?
7 witnesses. 7 witnesses left, Your Lordship. And he is in custody since 29th April 2015, Your Lordship. 29th April. और इसमें जो है antecedents का report दिया, Your Lordship. Most of the cases he has been acquitted. I have mentioned in supplementary affidavit, देखा जाए, Your Lordship. I have annexed the judgments also, Your Lordship. Apart from the present case, the petitioner has the following cases, Your Lordship.
Supplementary affidavit.
Yes, Your Lordship.
When did you file the supplementary affidavit? It is not on record.
Yesterday night I sent through mail, Your Lordship.
No, file it.
Mail se file kiya. Next.
Yes, next week. Come on, as the supplementary affidavit which has been filed by the petitioner is not on record. Yes.
Serial number 16, CRMP number 229 of 22, Mr. Ajit Kumar.
This is restoration of CRMP, my Lordship.
Defects removed?
Yes, my Lordship.
No, defect in the main CRMP.
I'm ready to remove the defect, my Lordship.
The constable of the petitioner submits that the CRMP number 3533 of 2019 was dismissed as the peremptory order was not complied with. Full stop. Next line. He submits that no sooner this CRMP is restored, he will remove the defects. Full stop. Next paragraph. Considering the submission, this the CRMP number, this instant restoration application to restore CRMP number 3533 of 2019 is allowed. Full stop. The counsel for the petitioner is the petitioner will remove the defect which was pointed out in CRMP number 3533 of 19 within 2 weeks.
Under the heading for hearing, serial number 17, Criminal Division 973 of 2008, Mr. Manish Kumar, Mr. Rajesh Kumar Singh for the petitioner.
May I please, my lord? This is a case, my lords, which was filed much earlier in 2008, challenging the order by which, my lords, rupees 3,000 was directed to be paid to the wife and one son, my lords, on the ground that at that time it was alleged that the petitioner husband was having an income of 5,000 rupees as he was working temporarily in Messrs. Tata Motors, my lords. Since then, the case was admitted, my lords, and direction was given to continue to pay rupees 2,500 per month, my lords. So I don't think, my lord, there is much to be argued here, my lords. Maintenance order has under challenge, my lords.
I'm dismissing it.
Yes.
3,000 was the maintenance amount.
What is it?
And for OP number 2.
You are receiving the amount now?
Presently, I am not in touch with you, but earlier I was receiving 2,500 pursuant to the order. And
so the balance 500.
Yeah, there are order of this honorable court, my lord, to pay 2,000.
After dismissal of this, you have to pay the balance of 500.
Yes.
Certainly, my lord.
Okay. Heard the counsel for the petitioner, heard the counsel for the state opposite party. What's up? This is an application. In this revision application, the petitioner challenges the order dated 6/8/2008 by which an amount of rupees 3,000 was fixed as maintenance in terms of section 125 CRPC to be paid by the petitioner to the opposite wife, opposite party. Opposite. The aforesaid order was passed in Miss Case number 28 of 2004. The principal family court, Principal Judge Family Court, Jamshedpur. Full stop. Mr. Manish Kumar, appearing on behalf of the petitioner, submits that the amount awarded is exorbitant. So he submits that the petitioner is a temporary worker. Is a temporary worker in Tata Motors. Tata Motors, and he's ready to maintain the wife and his child. So next para. Ms. Amrita Sinha, appearing on behalf of the opposite party, wife, submits that there is no dispute that this uh, opposite party is the wife of the petitioner. First up, she submits that there's a child aged about 6 years at the time of filing of this application. She submits that since the
Two childs were there.
two child,
One age 6 and the other 3.
3 years, 6 years and 3 years. She submits that since admittedly they are the wife and children, comma, the petitioner is duty bound to maintain them. First up, the petitioner, according to her, the petitioner fails to maintain the wife and children, thus the order needs no interference. Next paragraph. After hearing the counsel for the parties, I have gone through the impugned order, I have gone through the records. The fact that the petitioner is the husband of OP number
2
is not disputed. First up, it is also not disputed that out of the said marriage, 2 children were born. First up, the trial court, the family judge has found that the petitioner, that is the husband, has neglected and has failed to maintain the opposite party and the 2 children. First up, the quantum of maintenance which the trial court has fixed is only 3,000 rupees. First up, this amount by no stretch of imagination can be said to be exorbitant, as the wife has to maintain herself and 2 children. Full stop. Thus, I find no good ground to interfere with. Full stop. Further from the order, I find that there is no illegality, impropriety committed by the family judge in deciding the application. Full stop. Thus, I find no merit in this revision application. The same is dismissed.
Online mode.
Much obliged, Lordship.
Serial number 18, Criminal Division 414 of 12, Mr. Nishit Kumar Sahni, Ms. Gauri Devi.
My Lord, I am appearing in this case. This revision is against judgment of conviction affirmed in appeal. Conviction under section 138 of the NIA, and sentence was SI for 4 months with a compensation of rupees 2 lakh. My Lord, the complaint was lodged on 23rd to 2005.
You are on bail?
Yes, I have been granted bail by this honorable court on 26 June 2015. Before that, I was in custody.
You have stayed in custody for
15 days.
15 days.
Yes.
And what is the fine amount? What is the check which was dishonored?
The checks, there are 2 checks, each of rupees 50,000 that were dishonored due to the reason account closed.
Yes, that will attract 138.
Yes.
So 1 lakh, total 1 lakh rupees.
Total 1 lakh rupees. And
so now what is your ground?
That checks were alleged to be issued against a loan provided 2 years back. My Lord, only on behalf of this petitioner, my lord, the defense is that the petitioner issued the checks against the materials to be supplied. Admittedly, both the parties are businessmen, and their shops are in the same premises. The defense is that the checks were issued against the materials to be supplied, and the liability was not proved. The complainant could not prove the could not produce any document regarding the loan provided to the petitioner. And another defense is that the demand notice was not served to the petitioner.
Where is the complainant? Anyone appearing on behalf of the complainant?
Yes, Your Lordship, I am appearing for the complainant.
What is your case?
Yes, Your Lordship, my case is that we were having the shop in the same premises. During the course, he just lent 3,50,000 as a friendly loan because we were knowing each other since long. Therefore, no document was exhibited. Thereafter, he said that he will be paying thereafter. He issued the 4 checks in total.
His case is that he issued 4 checks.
Yes, Your Lordship.
Against delivery of some material.
That is what, Your Lordship, the finding is there that 2 contradictory stands were taken by them. At one stage, he's saying that we were in a process of some material exchange. Thereafter, he is stating that material was already exchanged. And the court went on that the presumption, he has not denied the sign over the signature. He has not denied, not even any agent.
Any chance of settlement?
Yes, Your Lordship. Earlier, they took time before this
Sani,
on the ground that they will be paying the amount. However, they have not paid a single money since then.
Both the courts have convicted you.
Yes, my lord. At present, my lord, the client is not in contact with us. So I shall pray for some time.
Contact him.
Yes.
Mr. Sani will try to establish contact with his client and inform this court as to whether there are any chance of settlement of the dispute or not, as the petitioner is a convict for allegedly committing an offense punishable for committing an offense for committing an offense punishable under section 138 of the Negotiable Instrument Act. It will be better if you try to resolve the dispute. And also, Ms. Sinha,
yes, Your
whatever you get.
Your Lordship, we are ready to compromise. The only thing is they are not helping us, and we at the earlier stage also we said that we are ready to compromise.
If I dismiss it, you have to go behind the bars again.
Yes, Your Lordship, if it is being dismissed. And we are ready to compromise, Your Lordship. It is not like we are not.
Okay. Next. Okay,
Number 19, criminal division 1148 of 40, Mr. KP Chaudhary.
In the next matter, Your Lordship, I am praying for some time. I am not ready with the matter, Your Lordship.
What is the matter? At least you can tell me.
Yes, Your Lordship. It is matter is against the offence is against 420, wherein he was convicted under section, and that order is under challenge, Your Lordship. Wherein he has been given imprisonment of 3 years and to pay a fine of ₹20,000. The case of the matter is that, Your Lordship, that in brief in para 3 it is written that the case of the prosecution in brief is that the accused has been running an office and he came in contact with informant Kaushal Kumar and others. He took ₹11,06,500 from 23 boys and assured them that he will provide job to them in abroad. It is further alleged that he did not give any of the boys passport, and when asked for, he tried to escape, after which he was caught and FIR was lodged against him. However, my particular case is, Your Lordship, that I was working under some company and the entire amount which was taken was deposited to the company. I have not kept a single penny with respect to that amount, Your Lordship, and I was just performing my duty towards the company.
What is your statement under 330?
330. Your Lordship, I am not ready for that reason. I just prayed for time.
313. Have you taken this ground in 313?
I'm just.
Or it is a simple denial. ऐसी बात नहीं है.
Ma'am, देख लीजिए, Your Lordship. Just give me a moment, Your Lordship.
What is 313? As I apprehended.
313.
Do you have a copy of 313?
No, Your Lordship, I don't have that copy.
It's only one paragraph. Listen. आपके विरुद्ध साक्ष्य है कि आपने वादी कौशल कुमार एवं अन्य 19 लड़कों से नौकरी दिलाने के नाम पर 11,06,500 रुपया तथा और 23 लड़का को पासपोर्ट विदेश में नौकरी दिलाने के नाम पर ठगी कर लिया है। क्या कहना है? गलत है। सफाई में क्या कहना है? मैं निर्दोष हूं।
Your Lordship, I need to verify the records, Your Lordship. Just one date may be given. I will be coming with full preparation, Your Lordship, and then I will be assisting, Your Lordship.
2 weeks time as prayed for by Amrita Sinha, counsel appearing on behalf of the petitioner. Kama is allowed. List this case after 2 weeks.
List over.
List over.
Much obliged, Your Lordship.
Thank you.